This is the current federal tax developments for the week of September 9th, 2024. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. I'm Ed Zollers, and this week we're going to talk about a few things that happened. Again, looking back to our issues with the beneficial ownership information report. Talk about some additional clarifications from some online discussions I've seen regarding whether a CPA firm does or does not need to file a BOI report, and confusions about reporting by entities that don't register with the state formation, which do file tax returns. And a lot of the confusion we're getting from CPAs over those situations here with the reports. And we're getting a little concerned because we're getting close to the end of the year. We're getting close to when things either need to have been filed or we are late, and especially to the extent that we are advising clients based on some of these same assumptions where people are getting confused. That could get very expensive, and also fouling up your own filing is not exactly a good thing either. So we're going to try to get this, understand where the problem is, why we have a problem, and then hopefully, make it so you understand what your obligations are. So we're going to start with this. The problem began when the FinCEN issued back early this year the Small Business Compliance Guide. And actually, I think it was late last year they did it. It's version 1.1. There was a 1.0 version, and then they updated it for 1.1 in December of 23, right? It was last year. So last year we got this book. And I believe this change took place in the version 1.1 version. So that was the one people started looking at in January of this year, when people suddenly became more and more aware of the beneficial ownership information reporting issues and started looking at this in detail. And also why, you're going to find that those that took BOI courses back in 23 probably don't have this misconception. But those who didn't start looking at it until this year probably do, depending upon what they looked at and depending upon, what kind of instructions they got, and how much time the person instructing them had actually spent at looking at the law, as opposed to looking at some summaries. Because that sometimes happens that, things get presented based on summaries, and, well, summaries can get you in trouble. And I think in this case, for a lot of people, they may get them in a lot of trouble. So we'll talk a little about this. A number of online groups, two this week I had, raised essentially the same question. And there were a number of CPAs that provided a response that had the same wrong assumption, and I know where they got the assumption. I can point you to the exact page where they have the problem, which is page 4 of that manual, but also show you why, if you go with that, it's going to prove very embarrassing, because page 5, the next page, will make it clear pretty quickly that, hey, the assumption you made when you relied upon page 4 alone, that's not supposed to be relied upon on its own for everything, because there's a whole bunch of other things back here that make no sense if that told us everything we need to know. So the big problem we have is there's a belief that all accounting firms qualify for an exemption. So accounting firms would never, ever, ever need to file a BOI report, regardless of whether or not they'd be a reporting entity, because even if they're a reporting entity, a reporting company, I should say. I got to get the right term there. It's called reporting company is the term they use. If it's a reporting company, otherwise it would be covered by this broad exemption. And let's put this very simply. For those who don't want to wait a lot of time for the explanation, that answer is wrong. They do not all qualify for this exemption. Absolutely do not. Stop. In fact, it is far more likely to your accounting firm if it is a LLC, variant of an LLC, limited partnership, PC, etc., has to file, than that it doesn't. So that's way, way more likely to be true. We'll talk about what it needs to be true, but that's the most likely outcome is you need to file. Confusion also arises of what happens if this entity we're looking at here, a quasi-entity, is a sole proprietorship, legally, not a single member LLC that's pretending to be a sole proprietorship for federal income tax purposes, right? Or as Jim Hamill would call it, lying. What lie are we going for with LLCs? Because under federal tax law, there is no such thing as an LLC. So we have to lie. We have to say it's something it isn't, just so we get in the right federal tax category. And so, which, if we have an LLC in the mix, we're lying. And while income taxes pays attention to that lie, the Corporate Transparency Act does not. Corporate Transparency Act knows what an LLC is, and LLCs are treated directly under the law. While in the Internal Revenue Code, I think we may have one reference to LLC in the code, and that's not really about entities at that point. We don't really have, basically LLCs aren't referred to there. They're specifically referred to in the Corporate Transparency Act. An LLC is a reporting entity or a reporting company, period. Right? I don't care what it claims to be. It's going to be that. And conversely, if something is a true legal sole proprietorship or a true legal general partnership, it will not be a reporting entity, a reporting company. Right? We'll talk a little bit about why that's true. We talked about it last week, but basically it hasn't changed. It's true for the same reason. Now, where the confusion occurred is FinCEN came out with the FAQs back in 2023 early. And, they explained things, but they were rather technical in nature, right? So for all 23 exemptions, they pretty much just repeated word for word what the statute said. So all 23 just reported what the statute said. So bottom line, that was there, and that was thorough, and that was correct, and that would not have misled you. But effectively, they got complaints, I'm sure, from various parties. I'm sure that even probably GAO may have gotten involved knowing the way that works, saying, well, this isn't effective because it's way too technical, written in language. We need to simplify it, make it easier to follow. And so they took that FAQ, expanded it quite a bit, and created the Small Business Compliance Guide. And remember, they expanded it, which is one thing to remember about what happens here, because this is kind of how we get into this trouble with this structure. But the simplification led to an unfortunate page break and a table that a table that a lot of CPAs are treating as the only source you need to look at to determine if entities exempt. And again, that is not the case. If you're going to tell me a CPA firm is exempt and you're going to point me to page 4 of the Small Business Compliance Guide, I'm going to tell you, go ahead and read the next 10 pages. Come back and tell me if you still believe that. Because we'll get into what that table really is, and what it is not the absolute guide to definition of who's covered by an exemption. And if you read accounting firm in that table, and you think every accounting firm of any sort, of any type, in any state is exempt, you are wrong and demonstrably wrong. Much more narrow than that. So here is that table. Now, there are 23 exemptions. That's been true all along. But note that this table has 2 titles for the columns. Column 1 is exemption number. And we'll find that important later. There's a reason why we have a number for each one of these. Because you don't really need a number in order to, decide if it's exempt. If in fact, the second column tells us exactly, fully, without question, the full definition that is crystal clear, who is exempt. Hint, it's not meant to do that. If you look at the title of the second column, it says exception short title. Now, short title is a legal term we see often in statutes, that there'll be a short title given to something. And by the way, the titles generally, except to resolve an ambiguity, have no impact on what the section that's referring to means. Only if it was unclear what was meant by accounting firm, the theory being, if this was the way the statute was written, which it's not, but if it was, only if it was unclear would they use that term to help fill in the blanks about what the statute meant. But these short titles are simply placeholders. They're meant to allow us to find the things we need to find to then get our true guidance. And what caused the problem, as you may expect, was number 15. Number 15 says accounting firm. Unfortunately, too many CPAs decided that that meant that their firm automatically was exempt. And it's unfortunate where the page break lies as well, because there is additional stuff you need to use to make sense of this that is on the following pages, but the way the page breaks flop, if you don't turn the page, you will not notice that additional stuff you have to use. And it tells me a lot of people stopped on page 4. Never went beyond page 4, or never went beyond the FAQ that just has this table, but doesn't have all the explanations. It tells you to go look in here, but most people are just seeing the table, focusing on what they want to see. Remember, we've told you more than once, a confirmation bias is a huge risk factor when you're doing any sort of tax research or legal research. You know the answer you want. You know the answer you'd prefer to be the answer, or the answer the client wants. And the problem is, people who succumb to confirmation bias will tend to do a couple of things. One of the things they do is what's going to kill you here. As soon as you find something that supports the answer that you want, especially if it's the first thing you find, you will decide that that piece of data is the entirety of any support necessary for the position you want to take. So if you would prefer not to file a BOI report on your accounting firm, which you probably would, I don't think anybody really says it's great to be filing that report in terms of providing that data to the public. You might think the overall goal of the law is fine, right? To handle criminals, etc. But your accounting firm's not a criminal enterprise. So, we're just putting that data out there to FinCEN, which they're going to have, and they're going to have to try and protect. But in any event, that's all we know about that. So your bias is to stop here. The danger with stopping here is, plaintiff's counsel, if you're talking about where you did this for a client and you just kind of decided that, oh, well, entity assisting a tax-exempt entity, oh, that's all I need to know about that. That's all definition means. So as long as they assist a tax-exempt entity, they don't need to do it. And you told one of your major clients, hey, don't need to file because you do some work, like 5% of your work, assisting a tax-exempt entity, 95% is for profit. It doesn't matter, right, though, because you assisted a tax-exempt entity. If you made that decision, you would be roasted in court because plaintiff's counsel would have you read a few pages later what we're going to discover is the problem here. That is, we're going to find that there's more to this. So, like I said, CPAs appear to be relying on that table, either in the guide or in the FAQ page, to decide their PC, professional LLC, limited partnership, whatever the entity type is, does not need to file the report. And that's not good. As I noted, this is only a simplified titles that reference you to a full explanation of what each of these means. So what you're going to discover is, and this is what starts on the next page that you don't notice if you don't switch the page. Starting on the next page, there is a checklist for each one of the 23 exemptions. You see a few on the first page, you keep going, and these exemptions continue for all 23 exemptions. So that's your first clue. And these exemptions always are longer. In essence, there's a relatively long sentence generally that follows that is the question. That's your first hint that that little blurb, 2 or 3 words on that page, is not adequate to determine if you're exempt, right? Had you gone to the next page, you would have found this out. But you stopped reading. You stopped reading because you got an answer that you liked. See, confirmation bias says if that page said that CPA firms had to file, you'd have kept reading looking for an exception, right? Because you don't like that answer. But you stopped reading, and this is the danger. And look, you have to fight. you have to fight your preference to not do this, because it is so tempting to go down and have confirmation bias just run it. Your bias said, nope, I'm going to stop here. But if you had turned the pages and then you'd continued on and said, hey, here's one for exemption 1 and 2 and 3, maybe I should flip the next few pages, see if I find is there an exemption 15 checklist, which there is. So if you qualify as a public accounting firm, now here's the first thing that should clue you in that there's something up afoot here. Notice the heading here doesn't say accounting firm anymore. It says public accounting firm. Well, that's a condition. That would be a condition itself, that if the title was complete, why would you need to be a public? Why didn't I say public accounting firm? Because that wasn't the point of that. That was just give you a general description. And you're going to discover that public is a necessary modifier along with some other things, right? Public accounting firm. Because here's the exception. And this actually comes virtually entirely from the statute. If the entity is a public accounting firm registered in accordance with Section 102 of the Sarbanes-Oxley Act of 2002, public accounting firm for that purpose is defined by Sarbanes-Oxley Act, right? SEC rules in general. And Section 102 is where you register generally if you're going to be doing public company work. Most CPA firms are small. Most CPA firms do not handle public company work. Most CPA firms are not registered under Sarbanes-Oxley Section 102. So if your firm is not Sarbanes-Oxley registered, then you should be filing the report unless you could meet another exception. And the most likely one you might be able to meet, but it's probably a stretch, would be the 5 million, 20 employees, large operating entity exception. But my guess is if you're up in that range, you're going to have a much, much higher chance of actually having some public company work you do. So in any event, yeah, watch and keep that, because the key here is that Sarbanes-Oxley Act reference is directly from the statute. That condition is not optional. And you might say, but wait, I heard about the Supreme Court case this summer. In fact, we talked about it, right? That was Loper-Bright case. Well, didn't Loper-Bright say it was way easier to challenge regulations and this comes from the rule? It comes from the rule, but that rule is word for word parroting the statute. And one thing that Loper-Bright makes clear is Loper-Bright only affects whether a regulation or rule, final rule is the terms used here, is considered to be, binding. But going all the way back to the Germain case, U.S. Supreme Court clearly holds. And remember, the author of the Germain opinion, is Clarence Thomas. So obviously one of the parties involved who's very much on the side of saying Chevron deference should go. And regulations will need to be more easily questioned. But he very, very clearly said, if the statute is clear, we are done. I don't care what reg says. I don't care what committee reports say. I don't care if you can get every member of Congress come up here and swear, well, you didn't mean it. If you didn't mean it, then repeal it and put in what you did mean. In this case, they are quoting the law exactly. There is a reason why the challenge to the Corporate Transparency Act is a constitutional challenge attacking what Congress did and not a regulatory challenge saying that basically FinCEN went too far. Because FinCEN very much did exactly what Congress told. In fact, I think if you took a course from me on this, on the BOI report, I would have pointed out that this was a unique bill, or this bill that got rolled into a much bigger bill for funding for a year. It actually has a whole first portion that's non-codified that reads like a committee report. That what they did is they had Congress vote on and the president sign, well, or not sign in this case because it passed without his signature, and law without his signature. But in essence, everybody voted on what was essentially the committee report. That committee report becomes part of the law now, not additional information from Congress. And so it outlined virtually exactly how to write the final rule. That's why we're challenging it on constitutional grounds in the Alabama case and what's before the 10th Circuit or 11th Circuit It's not being challenged on the fact that FinCEN, that FinCEN exceeded their authority. Because even though we might say challenging regs is not easy, it's way easier than challenging the constitutionality of a law Congress has passed before the courts, to get the courts to throw that out. So, yeah, this is perfect. Do not say low per bright. I really am beginning to feel that too often what I've seen today, what I see these days is low per bright is being used as a catch-all to defend any position whatsoever, even if, like this one, clearly it doesn't impact low per bright. It's not there, right? This statute says exactly what you see in front of us here. The rule says exactly the same thing. So that's not a interpretation of Treasury. That's simply parroting what the law says. So yeah, your public accounting firm needs to file, right? That's part. Most CPA firms are small firms. That includes even ones that are entities that are reporting companies of a type that come under this rule. The vast majority of them are really, are small, very small entities. Most of them are not registered under Sarbanes-Oxley. And registration is necessary to qualify for the public accounting firm exception. You're not registered under Sarbanes-Oxley, you don't qualify for that exception. So if you are a reporting company otherwise, you need to report, right? The same will be true if you're attempting to determine if a client entity qualifies for an exemption. You can't just go off that one-page list. If all you have is those 23 items on that list, that nice list I showed you there, if that's what you're working from, you better expand your horizons, right? You need to go get the following pages in the Small Business Compliance Guide, whether you got that list from the FAQ or from this, in essence, from the guide. You need to go get the remaining page. You need the checklists, right? At the very least, you need the checklists, which are way, way, way more complete as to what's required to qualify for an exception. Now, like I said, as we noted last week, too often CPAs are attempting to apply tax rules to a non-tax law when you're determining what to do about this reporting, right? An activity can be not a reporting company, even though that activity is reported on any of these forms. A Schedule C, E, or F on a 1040 or a 1041. Does not mean it's a reporting entity. Doesn't mean it's not, but it doesn't mean it's a reporting company. It might be or it might not be. You cannot get that answer simply by knowing what tax form it files. Can't do it from that standpoint. If somebody files a Form 1065, that also doesn't tell you, because entities or quasi-entities that are exempt, that are not reporting companies, qualify to file a 1065, certain types there, general partnerships being the big one. And there are entities that are reporting companies, right, absent qualifying for an exemption, that can file a 1065. Anybody under the check the box rules. Most things under check the box are going to be reporting companies. And they're lying, right? They're lying about the fact that they're saying, hey, because you don't know what LLCs are, I'm just going to tell you I'm a partnership. Or I'm going to tell you I'm a proprietorship, right? And because I operate a business, I put me on Schedule C for my individual, or maybe put me on Schedule E if it's a rental, or Schedule F if it's a farm, right? But that's how we do it. But if I'm lying, and I'm using an LLC, then that is a reporting company. If I have everything titled in my own name personally, I'm a legal sole proprietorship, I don't have to file. Same thing if I'm a legal general partnership, not a tax partnership. Partnership, federal law for income purposes literally just knows partnerships. That it considers it a partnership. So that's one of those odd things to keep track of. Right? So the key issue is, this is where the confusion comes. The Corporate Transparency Act Beneficial Ownership Information Reports looks at legal entities, not tax entities. That's crucial to understand, right? For making an initial reporting company determination under the law. The following legal, which kind of aren't entities, would not have a BOI reporting obligation. A true sole proprietorship, legally, which means One person owns it. That person owns every asset in their own name, not through an LLC or or whatever other type of entity type we're talking about here. But generally, a single LLC, it doesn't own it that way. So that's sole proprietorship. Joint tenancy. Right. That is a title holding option. It's not an entity type. And you don't really have to file that with the state. You probably will file with the county. You know, if you're going to say, like, we're going to put our house in joint tenancy, we'll do a deed and file the deed. But joint tenancy is merely the way it's held. The title it's held in. It's not an entity type in of itself. And a general partnership. Right? A general partnership would not have to file because it's not a legal entity that needs to register with the state. That's where things get interesting. This flow chart we saw last week. It's important to review it. Go back here. If you have any confusion, start at the top for domestic entities. That's what we're worried about here today. First question, is your entity a corporation under state law, not under tax law? Under state law legally. Is this thing an INC? Not an LLC pretending to be an INC for federal tax purposes, or an LLC pretending to be a, let's say a sole proprietorship. Is it an INC? If it is, yes, it's in. Next question. Is it an LLC? I don't care what it says it is for tax purposes. Is it legally an LLC? If I would go look for liability purposes under the state's limited liability statutes, limited liability company statutes, and to make sure it qualifies for that protection, that's an LLC, right? Formed by registering with the state. Generally, you have to register with the state to get your ILC. Finally, is it a type of entity that's similar to those two, but, and is created by a filing with the Secretary of State or similar office at the state or Indian tribe level, state, Indian tribe or territory level? Again, if any of those questions are answered yes, then you have a reporting company, and you have to look to see if you have an exemption to get it out of having to file a report. If the answer is no to all three, then and only then do you have something that's simply not a reporting company to begin with. We don't need to worry about that. So, take away from this, make sure you understand the rules. Make sure you're clear, and make sure that you're not shortcutting how you're reading about this stuff. Right? It is concerning that we're getting this close to the final due date, and a lot of people are still this confused about whether even their own accounting firm has to report. So we need to kind of work that out. Well, this has been the current federal tax developments for the week of September the 9th, 2024. Current federal tax developments are brought to you by Capital Financial Education and by your state society of CPAs. I'm, as I said, Ed Zollers. I'm here in Phoenix this week. We might actually break our consecutive day record of 100 degree or higher a week from yesterday, I guess. So coming Saturday. Right now, I'm looking at a tentative high of 99 and a little bit lower in days after that. If that holds, we'll actually finish this thing. We haven't had a day with a high below 100 since May. Here in Phoenix, that's just how it's worked. I usually monitor, like I said, Ed Zollers at currentfederaltaxdevelopments.com. You can send questions there. You can also, I do go ahead and read the comments and questions in the Connect sites for Arizona Society CPAs, New Jersey Society, Illinois, Minnesota, Washington, Idaho. All of those are covered. If you're in any of those states, you post a question, I may see it. And if I think it can help, I may go ahead and give an answer. But otherwise, thank you for being here this week. Remember, this is the final deadline coming up for past due entities is this week. So hopefully you've got all those under control. If you're really lucky, you've got them all already filed. Usually we always end up with a couple of stragglers that can't get all the details in to the last second, but we'll hope that that's not your long-term problem. And we'll see you back here next week for more current federal tax developments.